Good morning. You're very welcome to the latest in the series of Selig webinars for CEF. My name is Mark Spence, Managing Director of CEF. I'm joined this morning by Adrian Kerr, partner with Selig, and I'm McGuinness from Vantage 3, and they will introduce themselves as we go through. I want to welcome you all this morning on this webinar, which is on legal and technical considerations on time-related claims, which is, I know, an important topic for the industry and a key topic. But I also want to thank Selig for all of the webinars you've done this far this year. Adrian, your team have done a great duty for us. You've covered accidents in the workplace. We've covered corporate governance, directors' duties. We have more to come. We have another half dozen or so webinars in 2022, energy projects, drones and technology, succession planning, terminations, and more. So please go to the CEF website and book your place on all of those upcoming events. But we are very grateful to Selig for their support as patrons of CEF throughout the year, not only in the form of these webinars, but also in one-to-one queries, which is part of your membership benefits. So do make use of that. If you have a contractual query, do contact the team at Selig. But this morning's topic is very relevant, and we have two of the industry leaders giving us this presentation this morning. We're very grateful for your time, Adrian, and Niall as well. So Adrian, with no more ado, I will hand over to you, and I would just ask if anybody has questions throughout the morning, please use the Q&A function. You'll find the Q&A at the bottom of your Zoom screen. That allows you to upload questions, and we will field all the questions at the end of the presentations. So over to you, Adrian. Thanks very much.
Great, thanks a million, Mark. I'm just going to share my screen and hopefully do it really seamlessly. Give me a second. Hopefully that's us up and running. Happy?
Perfect, Adrian. Great.
Perfect. Well, look, Mark, thanks very much, and thanks to everyone. So many people for joining us. I was going to say on this cold winter morning, but nobody's probably left. Well, or maybe some people have managed to stay at home like me. I'm personally delighted to see so many people logged into this. So my name's Adrian Kerr. I'm the head of the construction practice at Selig. I'm specialising and working in construction all day, every day, and sometimes into the evenings. Look, firstly, I just wanted to say and reciprocate back to Mark there and the team at CEF, not just for hosting this webinar today, but just more generally. This is our first year being a patron with CEF, and it's been a great experience. It's helped us create new relationships with, I suppose, many CEF members. As Mark said there, they've got the ad hoc queries that come through, but also the opportunities like this one today. And I also would really like to say thanks to Niall McGuinness there at Vantage 3 for joining us. Niall's technical analysis, to be honest, is what pretty much really wins delay cases or claims. I often think that the legals on a delay case are sometimes just a window dressing. I wouldn't say that to Niall too much, but look, I think I'm very conscious that a lawyer talking about delay analysis is very dangerous territory, which is why we got Niall to help today. It's just something that I just do not do, and you'll see where I'm spinning things from a legal perspective in a moment. But Niall's the technical wizard. So look, we're all well used to Zoom meetings by now, but I still find it weird doing Zoom presentations. So I've got my slides over here. But when all said and done, I'm in the box room in the house where my son used to sleep, and nothing's going to change. I feel like I'm talking to myself. So let's whiz through. John Quinn, who's our marketing guru, I suppose, in the office, has made me include the sort of sales pitch slide. I'm not going to dwell on it. John, if you're logged in, I've done it. We like to pride ourselves, I suppose, on being local, on being independent, but perhaps most importantly, we like to think that we give high quality, specialised legal advice, and most importantly, in a down to earth manner. That's it. That's a sales pitch. John, I'm moving on from the slide if you're there. Look, from a legal perspective, I'm sitting in front of a virtual room full of people who know the construction sector a hell of a lot better than me and understand what's going on a hell of a lot better than me. But one of Selig's values, and perhaps its most important value, is to try to be positive in terms of how we present advice and just generally. So when I was preparing for this webinar, I was trying to think how I would give my thoughts on the current status of the construction sector from a legal perspective, while remaining true to that value of the firm, positivity. I suppose the big positive for me over the past year or two has been watching on as you guys in the construction sector pretty much just battered on the whole way through a global pandemic while the rest of the world stopped. That was pretty mind-blowing, and it's a great credit to the entire industry that an enormous amount of projects simply kept going while pretty much everything else stopped. That said, sometimes being positive means saying it as it is, and I can't sit here and be happy-clappy on this call due to the nature and types of phone calls that I get at the moment. Everyone here knows what the world out there at the moment is like for those in the construction sector. Times are tough for various reasons, and what I'm seeing is an increased an increased willingness for parties to construction contracts to adjudicate or litigate. I'm seeing projects in difficulty because cash flow has been a nightmare and impacted by, as I said, multiple market factors that we all know about. And I think what's annoying me most, I suppose, is I'm seeing public sector jobs stopping before they've even started, because public sector clients, or we'll call them publicly funded clients, don't have the ability to be flexible in the way that they want to be, or the support to enable them to do what seems to be just common sense. So, and then on the jobs that are underway in the construction sector and the public sector, the guidance that's been provided to clients and contractors, to my mind, a lot of work went into getting it. I appreciate that, but it's frankly a bit too wishy-washy, and we'd like to see a bit more meat in those bones so that public sector clients can do what they want to do, which is get projects going and have the finances to do it. So look, all this combines to lead, or to sort of create a market where tensions are a wee bit high and money is tight. Nothing new there, I suppose, but it's a wee bit higher than normal at the moment, and I think, and that means that claims are on the up. Disputes are on the up for sure, and we are seeing delay claims being more prevalent than ever, and perhaps more sophisticated and complex than ever. So that sort of brings us neatly, hopefully, into where we're headed today. So we have an hour today, and anybody who knows the book by Keith Pickavants on delay in construction, I was going to get a copy of it, but it's in the office. There's a book like that, and we could spend all day talking about legals and delay analysis, but we've only got an hour. I'm sure Niall could do 8 hours himself on just the technical elements of delay claims, and I probably couldn't do 8 hours myself on the legals, but I'd give it a fair rattle. But what I wanted to do today was bring things back to being positive. And in the context of delay claims, I wanted to work out some high-level principles that maybe Niall and I could work to today. Firstly, from a legal perspective, and then with me, and then from a technical perspective with Niall, of course. So, out of necessity, we have to try and keep this to high-level principles, and hopefully, giving you practical advice, guidance, some things to think about, rather than what the temptation to do, which was reams and reams of case law and theory. So, you're probably glad I'm not doing that. So, sort of in high level ideas today, things that I would like to touch upon are how to avoid delay disputes in the first place. Delay disputes are ridiculously expensive. It's as simple as that, really, and therefore almost best avoided, like all disputes. But in a delay dispute in particular, it's not uncommon to see on each side of the dispute a couple of lawyers, a delay analyst, maybe even two, quantum expert, and then you might have a liability expert floating around in the background as well, dealing with other elements of the claim. All those individuals need paid, and let's not hide behind the door here. None of them are particularly cheap. So I'd like to chat about what legal tools or practices are available to avoid having to deal with the likes of me and Niall, I suppose, if things were to get too bad. And then moving on then, I suppose the way I wanted to try and think about was how you might gain the upper hand in delay disputes from a legal perspective. And I know Niall's going to touch upon how you sort of maintain and manage having the upper hand across the course of a project from a technical perspective as well. So I'd like to just draw upon some of the recent cases and matters that we've been involved in, lessons that we've learned from a legal perspective on how we see judges, adjudicators dealing with claimants and defendants in delay disputes, perhaps what they like, what they don't like, what makes them like one party more than the other, and why that might even matter. So at the end as well, we're going to just talk about one particular nuclear issue. I called it a nuclear issue to make it sound exciting. It's perhaps not that exciting, but I just wanted to touch upon a couple of issues at the end. So in terms of avoiding delay claims altogether, becoming embroiled in a dispute in relation to a delay claim is perhaps a better way to do it. Getting the contract right in the first place is always a good start. And making sure all the blanks have been properly filled out in the contract. As I said, that's always a good start. And I never fail to be astounded by the number of contracts that come onto my desk that haven't been completed and key elements are missing. So taking that into the realms of a delay issue specifically, two things spring to mind in relation to the contract not being right that I've seen causing issues. The first issue is perhaps something that some of you might be surprised about, but again, it amazes me how many times I'm asked for advice about a construction contract and there's no clear date for completion of the works included within the contract. In these circumstances where the parties haven't included a date for completion, you're in trouble really before you're even started. The reality in these circumstances is that it isn't the case that the job just has to be done when it's done. As you'll probably all know, the law dictates that if there's no clear date for completion, then the work has to be completed within a quote unquote within a reasonable time. I'm going to stop doing that. Within a reasonable time. So if there's a dispute about delay, the first thing that we'll have to get Niall and the delay expert on the other side to work out and fight about, I know Niall doesn't fight, but to work out and establish is what constitutes a reasonable amount of time to do the job in hand in the first place. So that means before before they even work out what's caused delay in the project, before we get into all the other cause and effect, all the stuff that we're going to be talking about in a minute, we have to try and work out how much, what the actual contract period is in the first place. And within a reasonable time as a concept is pretty nebulous. So look, it's just a mess. So no matter how good your relationships might be with other companies, agree with them a completion date and include it within the contract. I know that sounds like a really, really simple point, but it genuinely is something that I see with sort of worrying frequency. The next thing, which is delay related in relation to a claim, is you'll all be aware that within all standard form contracts, there's a box into which you insert the rate for delay damages or liquidated and ascertained damages or liquidated damages, whatever we're going to call it. So the mechanism or the number for late completion per week, per day, whatever it is. Now, I would often see, and again, with sort of strange frequency, LDs and delay damages being included as nil or zero. None of my business, really, to be honest with you. If two parties to a construction contract want to agree that there's no stick or carrot for completing on time in terms of finances, that's a matter for them. What I do have, however, a major issue with is the dreaded not applicable or N/A in the delay damages bit of the contract particulars. It's a wee bit like kryptonite to me. The reason that I think this is problematic and it creates grounds for dispute is that when things start running late, the delay damages clauses tend to still be in the contract when someone has done this. So, the mechanisms for penalties, I know that's the wrong word, but the mechanism within the contract for a financial repercussion in the event of late completion will all be sitting there in the clauses, but then at the front end of the contract, you've got not applicable. So in some ways, it isn't clear whether the parties meant there be no delay damages at all, or whether they meant that there's simply no rate. So the rate's not applicable, and the delay damages that are therefore, at large, and which would mean that the employer or the person up the chain in the contractual matrix would be entitled to recover whatever losses they suffer as a result of failure to complete on time. So on that one, it's not Niall who gets embroiled in a fight from the get-go. It's me to a large extent. And, we have to then duke it out to work out what this not applicable means, what the contract says. And then you have to go away and work out what the actual, ascertain what the losses are that flow from the failure to complete on time. And there's just a better way to do it. If you don't want if you don't want delay damages to be applicable to your contract, there's a way to do that, and it's just amending the contract provisions and making that abundantly clear. Not applicable, doesn't cut it. The next thing I wanted to sort of mention is that a good number of the disputes I see in relation to delay could have been avoided if one, or sometimes both, of the parties hadn't tried to bamboozle the other one with legalese. Now, I know that's rich coming from a lawyer whose fault legalese is in the first place, the existence of it at least. But I suppose what I wanted to say here is that there are some phrases that I see bandied about that just stir up trouble. And if people maybe hadn't have started talking about them in circumstances where they shouldn't, then the lawyers might never have become involved. So one of those phrases I often see people mentioning in skirmishes before I get involved is the notion of concurrent delay. Now, Niall will talk about that sensibly and properly, because I think in my experience, a good 90% of people who talk or mention or shout about concurrent delay don't even really know what it means properly, don't appreciate that there are multiple meanings to it. And their use of the phrase is often an attempt to not hoodwink, but convince the other party involved of something that just plainly lacks merit. And what they're doing there is driving people into the hands of the likes of me and Niall when they might not otherwise have done so. And before you know it, both sides are lawyered up discussing concurrent delay. Delay analysts are involved when a sensible conversation at a principal to principal level might have been much more appropriate. And that sort of links in with this point. Sorry, I was messing around with slides there. I think if you're, you got to bring the client with you. And, another phrase that I see people banding around is that all of a sudden time is at large. And again, I just wanted to mention that notion because it's something that I see recurring a lot where, two parties are entrenched in their position before the lawyer's involved and one party's claiming that time is at large and the other saying it's not. And I suppose what I wanted to say about that is time can only ever really be at large under a construction contract where something has happened. This is a very high level review of this point of law, but time can only ever become at large where I suppose something has happened. It has been caused by the employer and there's no mention of that event in the contract. So the contract doesn't contemplate for that delay event having occurred. So the difficulty of that is most contracts nowadays have pretty solid extension of time mechanisms, which means that the parties have agreed the circumstances in which extensions of time will be granted. So it's extremely, and I mean extremely rare for time to become at large. So again, 90% of the time that people are saying to their client or the person above them in the contractual chain, no, time is at large, the whole caboodle is off here, time must be at large. 90% are just bluffing and talking nonsense. And again, that stirs up trouble rather than actually having sensible conversations around the merits and using the sort of phraseology and technical claim or technical elements of a claim that Niall talks about. So before you know it, again, both sides are lawyered up and there's no going back. So again, look, that's a legalese. So that links into this idea of if you're making a claim, bring your client or the contractor above you in the chain with you rather than anything else. I suppose what did I mean by that? I suppose what I'm saying is that if people want additional time, to be awarded additional time under a construction contract, you probably want your client to agree to the entitlement before they go to their lawyer. Now, I'm not saying we should be removed completely from the process, but often lawyers shouldn't be in the mix here. And if a client considers that the extension of time is justified, then it's probably best they don't go to a lawyer or a delay analyst to check it. By the time you come to myself and Niall in a dispute, it's almost inevitable that there'll be issues with the claim. 15 weeks might be 14 weeks, or 15 weeks of a claim might be 9 weeks. And that's almost inevitable once you start forensically going through things. So I know I don't want to be teaching my granny to suck eggs here, but I think loads of the delay disputes that I've come across, the disputes could have been avoided if the person making the claim and seeking the delay extension of time had just spent more time making sure that their client could understand in a really basic way their logic. We tend to not be involved in delay claims if a client can be brought to the position where they can understand that X happened, therefore Y was delayed, and now the job's running late. And if that basic premise is, if you bring the client with you and that basic premise, it makes life easier. All too often I see contractors or subcontractors letting what should have been a decent claim sort of slip through their fingers because they didn't invest the time just bringing their client with them in the basic logic of what they're doing, and instead just land them with what looks like a pretty complex delay claim rather than sitting down and explaining it. I'm very conscious that I'm dipping into the commercial world rather than the legal world, but I'm just sort of, this is just based on things that I've seen and learned. In terms of, when you've been trying to avoid the dispute, but look, it kicks off, everybody's lawyered up now, or everybody's, got their claims consultants involved, or whoever it might be, and it's heading towards or in an adjudication or even a litigation. What I thought might be helpful is if we look at how people might gain the upper hand in delay disputes. So I'll probably, for the most part, talk on this about adjudication, but I'll also talk about how judges and the courts react to some things. So the first thing, again, basic stuff, but from a legal perspective, the best way to have the upper hand in any claim is to make sure you've done everything that was possible to do in accordance with the contract. Look, it just doesn't happen. I think we all know it doesn't happen on small jobs, on massive jobs. The contract just isn't followed in various ways for whatever reason, and adjudicators and judges just don't like it if you're the party who seems to be the person who just doesn't adhere to the contract generally, and not just in relation to the delay elements of the contract, just generally behaving as if you got the contract out and you've looked at it and you're doing things in accordance with it. Really assists in making sure that an adjudicator will be on your side, and that really matters. In terms of delay claims, I suppose, when it comes to complying with the contract, the big legal red flag when it comes to doing what the contract says is the issue around time bars and correct notification of delay claims. So most people are beyond aware now that within most NEC forms of contract, unless they've been amended or whatever, but within most NEC forms of contract, there's a provision requiring the claiming party to notify the event or its delay claim within a certain number of weeks. That number of weeks changes from contract to contract otherwise. And if it doesn't notify within that period of time, then it might lose its entitlement to its extension of time, or to the amendment to the completion date. Now, that's not just NEC now. What we're seeing is that requirement slipping into more and more contracts, and people are lifting the NEC style language and dropping it into all manner of contracts. So if it were me and I was involved in directly within an organization, within a construction within a contractor or subcontractor, I would be having a list of what's time barred and what's not, particularly in relation to EOT claims, and making sure everybody involved knows. And look, put it really simply, make sure you fire in your claim, notify your event on time. It's much better to get in what you might think is a lower claim on time than no claim at all if you're out of time. Again, a trite point, but worth making. I want to say something about time bars, which is a wee bit not dangerous, but I'm nervous about saying it, but I'm going to say it anyway. In my experience, adjudicators in particular really, really don't like quashing time-related claims because a party has failed to notify it on time. That's been my experience. So if you're in the position where you're defending a delay claim, it's something to be aware of. You might think you've got a brilliant legal point because somebody has failed to notify the event that leads to the EOT claim on time and it's late, or perhaps it's technically inadequate notification or something. But in my experience, adjudicators in particular are quite keen to find a way through that, almost in the interests of fairness. And I always find that funny because, when the NEC3 suite of contracts came through, it was all about project management and making sure everything's done properly up front, prospectively. And then now I'm seeing adjudicators quite reluctant to hold people to account on those clauses. Now, what I will say, however, is we're in a dangerous world because the courts are much, much more reluctant to let a delay claimant away with not notifying their claim on time. So a court is much more likely to uphold a time bar defence on a technicality. So that, which again makes a mess, because if we're in circumstances where an adjudicator is keen to find its way through it, and a judge then in the same dispute in a different forum finds the other way around, frankly, it's only the lawyers that do well out of that. So I just wanted to mention that because the timing issue is hugely important. I'm not trying to undermine how important it is, because I think adjudicators do tend to try and find a way through it, but ultimately if it runs into court, a judge might find the other way, which I just find a wee bit interesting. But nevertheless, key takeaways, I suppose. If you have a delay claim, make sure to check the contract, ascertain whether you might lose your extension of time entitlement if you don't notify your claim on time or within the period of time set out in the contract. And then crucially, the correct notification of a delay claim. I don't think an adjudicator would like to find against somebody for failing to do this, but contracts tend to provide very clearly how notices in relation to delay claims are supposed to be served, right down to, is it to be served by post, by, God forbid, fax, email, just in writing, whatever it is. Check the contract when you're making these notifications. Make sure that if it says you have to issue a notice, what are the notice provisions, which are often found at the front of the contract rather than in the delay claim section. And make sure you get it out. And I always say to people when they ask me, how should I send this? Should I send it by email and post, or what way should I do it? I said, send it by them all, because then nobody can say they didn't get it. So look, I'm not going to get into the detail of that anymore. There's case law around it. I refuse to discuss the Healthy Buildings case because everybody's sick to death hearing about it. But look, it's something that if you want to contact me about it, we can talk in more detail. Niall's going to speak later about the importance of good records and programs over the course of the project and all those lovely things. So I'm not going to mention it now, save to point out that updating the program over the course of a project is generally and highly likely to be a contractual requirement. So if you're going to have the upper hand in a dispute by grasping a sympathetic narrative with a kind adjudicator, then you want to be seen. If you're supposed to be preparing programs every month, then do it. Otherwise, it looks bad. To my mind, it just looks like you're not doing things as you're meant to. It looks like you might be aware of delays that you're not disclosing, etc., etc. So if you want to be seen by as being the good guy, just do it. Simple as that. And then, speaking of things being as simple as that, I imagine Niall might touch on this as well. But perhaps the biggest thing that I learned over the years in terms of successful adjudications and successful court cases, so it's exactly the same, is that you're less likely to win if your case is unnecessarily complex. With any delay claim, that's perhaps more important than in any other type of case. The work that Niall and his team does is like extraordinarily complex. But the reason that they're successful in what they do is that they can present their analysis in a manner that even I can understand. And I always think that if I can't understand, then it shouldn't be before anybody else, because if you sort of have to put yourself in the position where you're the least technically minded person, an adjudicator generally tends to be somebody who's technically minded, extremely experienced with hands-on stuff. So I always think that if I can understand the technicalities, then the adjudicator certainly will. So being able to present your delay claim in really basic layman's terms is invaluable. We couldn't do that activity until the road was finished, and the road wasn't finished because that happened. The change was instructed or whatever. Really simple stuff, and that's the sort of narrative that wins cases. And it's just it's a basic human trait. You latch onto the basic stuff, and if you can follow it, you're going to agree with it. If you can't follow it, you can't agree with it. So the red line program is great. The technical analyses are great. All the different types of delay analysis that Niall's going to touch upon is all really interesting stuff. But being able to describe, that critical path analysis in short, simple sentences is gold in any delay case. And you've a better chance of winning you've a better chance of winning with a straightforward, easy to understand case sometimes than a technically perfect case, which is just it's the way life is, isn't it? I didn't want to work through this session without mentioning the Society of Construction Laws Delay and Disruption Protocol, perhaps not least because some people maybe haven't heard of it, and if you're working in a job that involves delay at all, then it's worth a read. I know it sounds like something that you might never want to pick up off a shelf and read ever. It's 84 pages long, so it's not massive. There's the front end, which is a wee bit of guff, and the back end, which is a wee bit of guff. It's the bits in the middle that are pretty important and definitely well worth a read. There's sort of 30 pages or so there that you can wade through with relative ease. It's a document that was first published 2002, and then pretty recently updated to 2017, I think is the second edition, and it's quickly becoming sort of a go-to sort of Bible, really, when it comes to pretty much every delay dispute that I'm involved in. Either we mention it or the other side mentions it, or one of the other experts tends to bring it into play. So it's becoming a really important document. And as I said, it's 84 pages long. There are 22 core principles in that document, and it sets out what you should adhere to, what the principles you should follow when you're involved in dealing with delay, both in dispute mode, but before dispute mode as well, and just generally in how projects are managed. And one of the main reasons, as I said, why it's so important is not because we're referring to it, but because adjudicators and judges are increasingly referring to it for guidance on how to assess both the time and money elements of time-related claims. Now, it is dense, but it's free and easy to find using Google. So crucially, though, it identifies the factors that really should be taken into account by a party when deciding which type of delay analysis to use, for example. So it's a brilliant document. I'm going to say brilliant. I mean, it's really useful when you're in battle mode to wheel out if you can use it in your favor, because adjudicators like it and judges certainly like it. The next thing I wanted to say is about presenting your case to your client, and this sort of links back to the whole bringing your client with you, but it applies also to an adjudicator. You got to bring the adjudicator with you, and so this is really going back to basics here, folks. But I always know, every day I get calls about delay claims, right? So I always know when there's been a problem. There's a problem at the claimant end whenever the delay claim comes through, and they haven't mentioned a specific clause number in their delay claim when identifying the basis of their claim. And by that I mean, they haven't identified which relevant event or which compensation event by clause number under the contract has occurred and how that's led on to delay. Because I always think there's something funky there, and I would always be asking clients to push back and say, well, which relevant event are you notifying here? Because it usually indicates that somebody's trying to fudge an event or squeeze an event from real life into one of the listed events in the contract, and there might be a mismatch there. So with that in mind, it's always best, where you possibly can do, of course, to when you're first presenting your claim to the client, to say, look, this event has happened. This event is a relevant event or a compensation event under this clause. And look, that's step one, a very basic point, but it's amazing how often, again, we see that not happening. And immediately there's a dispute there about which event has been notified, which contract clause is supposed to be triggered. It creates legal issues that perhaps could easily be avoided. And adjudicators certainly don't like it if the claimant isn't able to demonstrate which contractual provision they're relying upon. And look, whenever you are identifying which contractual provision to rely upon, again, a very simple point, but often people have been to 1,000 seminars on NEC3 or JCT, and they wheel out the standard JCT provision, and without actually checking, of course, the contract to check if it's been amended, whether there's add clauses or schedules of amendments and all those things. So often, I see claims being notified and have to help the clients write back, or help the contractor write back to the subcontractor and point out that clause has actually been deleted. Try again. And if you're running up against a time bar and you're trying to notify times late in the day, for example, right up to the time bar, and you get the clause wrong, your goose could be cooked. So, look, then we're talking about identify your entitlement, and then I don't want to step into Niall's world, but then you're talking about cause and effect. Once you've identified what the relevant event is by referring to the contract, you're stepping into the world where Niall operates. So you're trying to show how that event has had the effect that it needs to have under the contract for there to be entitled to an entitlement to an extension of time. I'm going to let Niall talk you through that whole idea of criticality and the differences around that, because that's more for him than me. I thought it would be wrong for me to run through my thoughts on gaining the upper hand in delay claims without mentioning the role of the project manager. I actually feel immensely sorry for project managers in Northern Ireland. I know that might rub some people up the wrong way, but when you hear what I have to say, you might appreciate where I'm coming from. I see architects working on pretty huge projects, massively experienced professionals, with a huge amount of experience, but they either aren't interested in delay really, or they aren't frankly suitably qualified to be able to deal with the level of critical analysis that sometimes is required when dealing with a delay dispute. They're architects, brilliant at their jobs, but I think I've spoken to many architects, and they will happily admit that delay is something that makes them nervous. And I think it's a major issue in the construction industry here. There are many exceptions to it, of course, but there are big jobs running without updated programs, and delay is being dealt with in a very sort of, we'll describe it as a loose way, maybe an absence of discussions around criticality. And then when things go wrong, if both the claimant and the defendant haven't really properly considered criticality, which we would see quite often, no one really knows where they stand, and they're in battle mode. And it's only when the likes of Niall comes on board that the parties on both sides, that the parties really understand their delay claim. And by that stage, things have gotten very expensive. So I just wanted to mention the John Barker construction case, which really project managers or architects acting as contract administrators shouldn't be winging it when it comes to delay claims. If they've done this, they can expect an absolute kick-in by an adjudicator or a judge. So if you're on the wrong side of it, if you're dealing with a project manager or an architect who's administering a contract in a pretty loose way when it comes to critical delay analysis, then the upper hand can be grasped in any dispute by identifying that to an adjudicator and pointing out that the use of critical path analysis, even in simple terms, which can involve, and I will talk about it, but isolating the events that impacted the critical path to completion. That's received judicial approval, and you got to point that out to both a judge and an adjudicator and say that that's how things are meant to be done. At the risk of getting into a bit of case law around it, there's the courts have made it absolutely clear that any determination of delay claim made by a project manager must be grounded in logic and fact. And I know Niall's going to talk about that, but a project manager has to be seen to be applying the relevant provisions of the contract. He or she has to be seen to be making a logical and methodical analysis. And this is what the John Barker case says. There has to be a logical and methodical analysis of the effect of the delay event, and the effect on the program. And crucially, there has to be some sort of calculation of a critical delay, and there can't be what's known as an impressionistic general assessment of the delay. And I hear that an awful lot. Extremely experienced contractors saying, I've been doing this for 35 years, Adrian, and there's no way that's a 15-week delay. There's no way. That's 2 weeks at best. And if that's all you're getting as by way of an explanation when you put in a delay claim, it's not good enough. And an adjudicator won't like it, and a judge won't like it. And the way to make a judge not like it and an adjudicator not like it legally is to mention that John Barker case, which is worth looking at. But those three principles are in it, which with the ultimate, conclusion that you can't just be going around making general impressionistic assessments of delay claims. It's just not the right way to do it. You don't have to go full bells and whistles, full on delay analysis, but there has to be a proper calculation of critical delay. I'm just conscious of time a wee bit, but look, there is a nuclear issue that I wanted to quickly talk about. And I know I began today talking about positivity, but over recent months in the context of delay, I think unfortunately market forces have been quite been pressurizing subcontractors and contractors quite a lot, to the extent that there have been a couple of projects that I'm involved in that are so slow that things are pretty much grinding or have ground to an effective halt on site. And I wanted to touch upon what an employer or a contractor can do in those circumstances. When does a time-related claim or a delay issue become a breach? And that touches upon this notion of failing to proceed regularly and diligently. Most contracts, as you'll all know, include some sort of type of wording around this. Proceeding with due diligence, or failing, or a requirement to proceed regularly and diligently. So it's sitting there in JCT standard contracts. It's brought into most contracts if it isn't in there already. So what can you do? if someone is beyond slow and you're thinking, yeah, we might have delay damages here, but we're not going to get any project if this keeps up. And the unfortunate answer is that it's a classic lawyer answer. As you might imagine, it depends on what you can do, depends on what the contract says you can do. So I always come back to my constant, consistent position, which is dig out the contract and check. Now, an overarching thing on this, whenever somebody's slow on site, the natural propensity will be to, let's get rid of them and get someone else on. But, in order to do that, you got to be very comfortable that they are indeed failing to proceed regularly and diligently. And that means you got to understand what failing to proceed regularly and diligently means. So what does it mean to proceed regularly and diligently? And I wanted to read out what the court said on this. There's a case called West Faulkner Associates from the early 90s. I'm just going to read here and listen to this for a bit of jumping about. To proceed regularly means, as a minimum, attending site with sufficient in the way of men, materials, and plant to have the physical capacity to progress the works substantially in accordance with the contractual obligations. Diligently meant that the physical capacity must be applied industriously and efficiently with sufficient progress towards contractual obligations. A contractor's overall obligation to proceed is described as continuously and industriously and efficiently with the appropriate level of physical resources so as to progress the works towards completion substantially in accordance with the contractual requirements as to time, sequence, and quality of work. Now, you're a better man or woman than me if you're able to work out whether or not someone's on one of your sites at the minute and not doing what they really should be doing, whether or not they're failing to proceed regularly and diligently. So, with all due respect to the brilliant Court of Appeal in England, my reading is that the obligation to proceed regularly and diligently is pretty a wishy-washy definition there. There's a lot of words, but what does it actually mean? So a word of caution, if someone's grinding to a halt, dig out the contract, see what it says, find out what the words are, and be very careful, because in the absence of understanding exactly what proceeding regularly and diligently means, I'm not sure what it means. It's a really dangerous word to terminate a contract on that basis, because obviously a wrongful termination of a contract can lead to a big damages claim against you. So look, I'm doing all right in time, just about, I think, Niall. Sorry if I'm running a wee bit late, but that just leaves me to hand over to Niall for all the important technical stuff, really. I have no hesitation in saying that by way of introductions, Niall, wins cases because he's so great, and I can speak so sensibly about this stuff and simply about this stuff. So without further ado, over to you now.
Thank you, Adrian. Share my screen, guys. Okay. Well, thank you for that, Adrian. Thank you, Mark and the CEF for the invitation today, and thank you particularly. Adrian has said it already for the attendees. It's got a great number, and I've been down through the list. Some new faces and some dear old friends I see that I should probably get in touch with more regularly. Thank you for the introductions, Adrian. I made the note, a technical wizard. I don't agree, but it's probably going to go on my LinkedIn profile this afternoon. In any case, in my world, it's not so complex. It's simply an application of the facts, an determination of the facts with the application of critical path analysis. It is straightforward once you sort of get it, but it's time consuming, and it takes a bit of working through. But as a concept, it's not difficult. But I'll take the technical wizard bit. So what I'd like to do is I'd like to, if I can, demystify all this delay analysis and AOT, prolongation, causation stuff, and really let you know why you don't need to call me. I won't do a marketing bit as such. We're experts and provide expert opinion and expert advice in some technical matters relating to the construction and as-built environment. And we don't wander into Adrian's world of legal and contractual. or technical people, and we do that, and we provide those opinions with respect to technical engineering issues to some extent, QS and quantum issues to some extent, but our real bread and butter is Concurrent Delay, and that's what we get out of bed for. So what I'm going to do is I'm going to try and do the impossible. I'm going to try and talk to you about these issues in 15 minutes. If anybody's had the misfortune of starting a conversation with me on such things, they'll know that it goes on longer than 15 minutes. But look, I'll try my best. So I'm going to talk about programs, EOT and prolongation in terms of making claims, assessing claims, or in my world, the flip side of that is providing independent opinion. And I'll touch on disruption because it's part of the streetscape, although we don't really have much time to talk about it today. So programs then, so pre-claim, pre-dispute, managing your construction project, programs for managing time-related obligations. So as I see it, programs are statements of intent, which inform critical paths and therefore causation and entitlements to extension of time and potentially prolongation costs. I often get asked by claims consultants, should those programs be clear or should they be opaque in some way? And I always said, and what do you mean opaque? Why would you make a statement of intent in an unclear, opaque way? And the answer I get is because in doing so in such a fashion, it allows greater flexibility for making claims in the future. And that's a matter of policy. I can't really advise on that. But what I will say is, if you've got greater scope for making fictitious claims, then you will have lesser of a tool for determining causation and proving your claims, demonstrating and proving your claims. I'd be on the clear and straightforward statement side of that. Probably no doubt. So your programs also, appropriate level of detail is often advice we give, and that sort of helps inform critical paths. So if you have programs which have long activities and long overlapping activities, that makes it quite difficult to determine critical paths. So an appropriate level of detail is often found when your activities are finished to start. You finish one activity in order to start another activity. Now that's difficult, I appreciate, on building contracts. It's easier in civil engineering contracts, but it's difficult on building contracts due to the nature of the work, particularly on multi-floor buildings. But keep it in mind, more detail, without making it overly complex, more detail tends to help. WBS is simply a matter of presentation and work breakdown structure. Methods and resources I mentioned because people often see program as just a bar chart, but specifications for program will include methods for carrying out work and resources for carrying out work, and together with the program are a statement of intention as to how the work was going to be delivered. So we'll often be looking at method statements and resource allocations or intended resource allocations when determining critical paths over and above simply a bar chart. And then if you can, avoid open ends, unnecessary constraints to start and finish activities, and illogical logic, if I can say that illogically. Those things tend to distort critical paths and make critical path analysis and the demonstration of cause and effect more difficult. If you're looking for some good practice, there in the UK there's the CIOB, very recently CIOE planning protocol, and in the US there's the DCMA 14-point assessment. We refer to these sometimes to sort of to test the adequacy of underlying baseline programs. And anybody working with ASTA, the UK protocol, there's a ASTA bolt-on. I haven't used it myself. My colleagues in the office tend to use it, but it runs an analysis on the architecture of a program and spits out some sort of results to tell you how good or otherwise it is. So that can be quite helpful. And then things go wrong. That's why we're here, I suppose, today. Nothing goes to plan on construction projects. So what do you do when that eventuality arises? Do you report or hide? Well, again, that's a matter of policy. I have been a construction planner every month, updating the program, tweaking logic links to maintain a completion date when faced with delays. And I have to say, that was policy at that particular time, not to show delay, but it served nobody any particular purpose. The employer and resident engineer at the time weren't getting a true picture of the project and its progress, and the contracting entity that I was with wasn't really owning up and reacting to delays. And it doesn't end in a good place, in my experience. So on that policy decision, I'm sort of on the report rather than hide side. And Adrian has touched on notification, and you're going to find it difficult to notify if you're hiding the effect of delay. And those notifications can be done. There might be some legal points as to what a notice is for the purposes of a condition precedent. But that aside, when I'm looking at a project and looking to assess the causes of delay, I'm looking for annotations and explanations and reprogramming, mitigation and acceleration against delay. And then in reporting format, I'm looking at progress programs, progress reports, and minutes of meetings to find out what happened. And they're not all the facts on a construction project, but they can be quite insightful at a sort of at a first level. And the point I'm trying to make is that if you're able to run good project management, then demonstrating causation in your time-related claims can be a spin-off or a byproduct of just the same. And I'm not necessarily talking about textbook perfect program management approaches. I'm talking about doing what you can to put in place programs, monitor programs, report progress, report the effect of progress, and give notifications. And in a bit, I'll come to records generally. So just moving into some programming terms, I'll skip through these very quickly. Critical path, there's a definition. I think that's from the Society of Construction Law Protocol. The critical path is the longest path through the project, and importantly, the principle at hand is that a critical delay to the project has to reside on the critical path. If a critical delay doesn't reside in the critical path, then it didn't or isn't going to delay completion. That's the importance of critical path in the context of all of this. And then critical path analysis or critical path method is simply a way of determining the critical path. Sort of factually, but sometimes, unfortunately, there's a number of different types of critical path. So you'll see there's the as planned. That's the critical path at day 0 or on day X if you've reprogrammed the work. That's the expected critical path. I'm going to skip the as-built critical path. The contemporaneous or actual critical path is a critical path at any particular time during the project. Therefore, the critical path on which critical delays to the project at any particular time could reside. And I've yet to find a project where the actual critical path follows the as planned critical path. The critical path will change based on the effect of progress and perhaps reprogramming. The as-built critical path, sometimes the term as-built critical path is meant to refer to the actual or contemporaneous critical path. Other times, and you'll see it in some textbooks and indeed in the Society of Construction Law Protocol, it's a concept where you assess the critical path by starting at the end date and working backwards. In my mind, that doesn't stand up to scrutiny, because in an as-built program, everything is potentially critical. Even the gaps between activities can be explained in a reason. And when I see it, and I haven't seen it for years, but I've seen 2 this year already. When I see an as-built critical path, I'm expecting it to be very subjective. An expert has gone that way, and he's going to join up the dots working backwards to suit his client's case, if you can imagine that ever happens. But unfortunately, it does. No talk is complete without touching on concurrency, but I'd rather I didn't have to, for reasons which I'll explain. So this is a description of concurrency by John Murren, which was later adopted in 2011 in that Adyard Abu Dhabi case, and it's found its way into Keating construction. I don't fully understand it, I have to say, and no matter how many times I read it, I still ask questions. But it says the expression concurrent delay is used to denote a period of project overrun, which is caused by two or more effective causes of delay, which are of approximate equal causative potency. I think it's the bit equal causative potency that trips me up, because I think it introduces an element of subjectivity. This is better. So this is from Selig Cruises, and this really sort of nails concurrency, strict concurrency for me. And it's what the judge said was the importance in concurrency arguments of distinguishing between a delay which, had the contractor not been delayed, would have caused delay, because of an existing delay made no difference. That's on one side, and then the other side, and those where further delay actually caused by the event relied on. So what that means is that you can only have strict concurrency where two events, and concurrency tends to relate to where one event's culpable on behalf of the contractor and the other is excusable as far as the contractor is concerned, i.e. it's the employer's risk. So strict concurrency is where both those are running at the same time, and they're both critical at the same time. Where you don't have concurrency is if the contractor has delayed completion, and then comes around an employer delay, which, if it hadn't been for the contractor delay, would have delayed completion, but because of the contractor delay didn't delay the new completion, then that isn't concurrency. So this strict concurrency, that gives rise to the legal position at the moment in England, Wales, and Northern Ireland, I think I can say, where if there's true concurrency, the contractor will get EOT but not cost. But in Scotland, there's an apportionment, a dividend up of it. I won't go into the reasons behind that because I don't fully understand them and from the legal side. But the important thing to say is this strict concurrency, I'd like to say it doesn't exist, but I can say it very rarely exists. So quick maths just before I started talking. I reckon in this practice, we have assessed 1,000 years of critical path analysis. And in that 1,000 years, so you can multiply by days, you're sort of getting up to sort of, half a million days of critical path analysis, thereabouts. We haven't come across strict concurrency in all of that analysis. Sometimes it looks like strict concurrency at a sort of higher level, but when you get into the detail, it washes itself out, and you'll see there's separation between the two events. The other concurrency, which is the other concept which is described as concurrency and perhaps incorrectly, is the circumstance where a contractor may be excusably delayed with respect to completion and therefore due an extension of time. But sitting behind that in a non-critical fashion, the contractor is either pacing or being delayed. And then the question then arises, if that contractual delay can be coexisting, let's say, it's sometimes referred incorrectly, I think, as concurrent delay. But the important question that then arises, well, to what extent do prolongation costs run? Is it to the full extent of the extension of time, or does it need to recognize that the contractor was delayed in any case, although in a non-critical fashion, in a sort of a but for? So but for the employer's delay, to what extent would the contractor have been delayed itself? And I think that place in terms of loosely concurrency, I think you'll see that. You'll see that a lot. We see that in most cases. So how do you go about demonstrating EOT prolongation, and how do I go about assessing it if it ends up in my desk? This is a table from the protocol, the Society of Construction Law Protocol, and there's 6 different methods here. Some are better than others, which I will touch on. But the important things to point out to you are some of them are cause and effect. So they're led by the cause and trying to determine what the effect is or might be, or indeed what was in the past. Others are effect and cause. So you first go and determine what was the delay on the critical path, and then go and try and find. So you find the effect on the critical path, and then go and try and find the cause. The other thing to point out is the 2 colored columns. So if I just describe prospectively, contemporaneously, and retrospectively under the critical path column, prospectively means just looking from the start line forward. Contemporaneously involves determining the critical path at any particular time, that contemporaneous or actual critical path. And retrospective relates to that as-built position that I think falls down on a logical analysis. And then the other variant is how you measure the delay. That's the delay impacted determined column. Prospectively means it's based on a forecast, and retrospectively means it's actual. It's a measurement of based on fact. So that's from the protocol. And then if anybody's really, really interested, there's also the AACA, which, if I think I'm correct, is the American Association of Costing Engineers, QSs, I think, in our language. They have something similar. Their name, the terminology is slightly different, and they subdivide all of these. It's quite a tour de force in terms of a piece of work, but probably overly complicated. Turns up quite a lot when we're working in the Middle East. It gets a lot of traction out there. So if you're working in the Middle East in the near future, then maybe dig it out. Otherwise, very rarely comes up in the UK and Ireland. So they're the different ways of approaching it. So you might then ask yourself, so what? There's different ways of doing the analysis or making the demonstration, but the results are the same, of course, or are they? Well, there is actually a judgment where the judge managed to get the two experts to agree that whether one analysis was done retrospectively and one was done prospectively, and they agreed that either way, based on the same facts, the result would be the same. I'm not quite sure how that came about, because I wouldn't agree, and other experts wouldn't agree with that at all. The results are always different on the same set of facts. And to demonstrate the point, the Society of Construction Law ran this great delay analysis debate. Now, the great might be slightly overstated, but it is interesting. So they took the same set of facts on a made-up project on which the completion was 7 days late. And 4 different experts, for the purposes of the mock-up, ran 4 bits of analysis in the different ways you can see, on the screen. And they come up with four different results. So you'll see that the contractors favoured impacted as planned, which is the easiest place to go to. You're simply taking the plan, you're ignoring the effect of progress across the project and just making an impact for the excusable event. It gave the full 7 days. And then there's varying results across the other pieces. So which one's best for you? Well, the one best for you is probably the one that gives the best result, but so that might be the impacted as planned if you're a contractor, but you have to sort of consider whether it's sustainable in terms of scrutiny by the project manager, contract administrator, employer's agent, resident engineer, and indeed going forward, if a dispute arises, if it's sustainable under further scrutiny by an expert or by the courts, etc. So maybe just keep that in mind. Impacted as planned is off the shelf, ready to go, but it's unlikely to be sustainable because it ignores the effect of progress elsewhere, which is important to the root of the critical path and the effect of causation, the effect of the event you're relying on. I'll just show you. Here are some factors or criteria for deciding on a critical path method. I'm conscious that I've slightly overrun. But I'll try and finish up in the next 5 or 10 minutes. And thank you for those who stayed on. So these are criteria. Some of these are more important than others to me. The time available, Adrian Kerr and his clients won't care what time is available. They'll want the right answer in the most robust way. And why not? Of course, why wouldn't you? The nature and extent of quality of records and the program information available, well, they are important because I need the tools in order to do the analysis to get down to the facts and the effect of the facts. The form in which the assessment is made probably is relevant, but that and the proportionate approach there based on the value of the project or dispute, I mean, they're relevant, but neither of them take away the sort of burden of proof. So if you're moving into a dispute resolution form, they might not matter too much. However, the relevant conditions of contract, I think, are always the starting point, at least the starting point, for reasons which I'll explain in a moment. So typically we find that we're doing or faced with either a time impact analysis, which, going back to the colored table above, is determining a critical path contemporaneously, what was critical at the time, but forecasting the effect, forecasting the delay. Now, that is exactly what NEC prescribes, NEC 3 and NEC 4, and I think that fits with JCT type of language as well. The only difference between the two is that in NEC, done properly, the compensation event gets implemented, and therefore the forecast delay also gets ring-fenced, whereas JCT and those type of contracts allow the third party to make an allowance for extension of time and then review afterwards. We often find in JCT type of contracts doing an as-planned, as-built windows analysis. That's the bit you see below. So that's the contemporaneous or actual critical path and the actual delay. So that's as close as damn it as anybody can get to find out what actually happened. And we find ourselves doing that in the context of JCT because it's got that provision to review afterwards and to add to EOT, but not take away EOT. But quite bizarrely, from my sort of in my engineering head, Adrian might be able to explain it better, but quite bizarrely, we also find ourselves finding out what actually happened in the context of NEC disputes, where the parties have already agreed a prescribed approach to delay analysis and a prescribed approach to implement the delay once it's been assessed in a prescribed way. And for me, it just seems that I don't understand why that agreement wouldn't run through a dispute resolution process, but adjudicators, many adjudicators, if not majority of adjudicators we come across, do prefer to know what actually happened rather than rerun the mechanism or correct the mechanism that should have run. And I think if you get sort of higher up the dispute resolution pyramid to the courts, the cases tell us that the courts want to know what actually happened. Maybe that's the point we'll come to in the questions and answers. So what do the courts look for? I'm not going to read this, but I've underlined some of the key words. They look for facts. They look for factual analysis in those two cases. And here, these cases are a sort of a tension where experts are doing two different things. So in the first one, the court preferred facts over computer simulations. Second one, facts over computer simulations. Third one, facts over, I can't remember, something else. And the fourth one, facts over something less factual, something modeled, perhaps. So how do you get to facts? Well, the answer to that is records. I don't know who penned that records, but it's true. I think there's no getting away from it. Here, from my perspective, are sort of good and bad are the wrong words, but maybe effectiveness is this rough sliding scale of records which are of use to me over records which are of less use. So you'll see at the bottom, letters, they tend to be not much use to me because they tend to be parties just pointing the finger at each other. Whereas up at the top of the scale, if a client comes with a fully referenced as-built program, I have to say that's cutting out most of the time that we need to spend in doing delay analysis. Okay, that's what we will do before we move on to determine critical path and measure delays. And if it hasn't been done, we'll be looking in photographs, site diaries, allocation sheets, minutes and meetings. I see progress reports quite low down there. I'd probably bring it up. It's low on my list because I often see the progress reports a bit. It goes back to that reporting delay or not reporting delay point. Sometimes progress reports aren't really, they're saying what they want to say rather than what's factual. But facts, records. And the point at the start is if you run robust project management, program and project management systems, then you'll largely be doing a lot of this as you progress. Quick touch on disruption. Look at disruption, everything so far in terms of EOT, it tends to be single causation points. So there was a single event and what was its effect. Well, there was an effect, what caused it. Disruption is an arena where there's many causes and many effects, and linking one to the other is very difficult. So what works are lots of facts again, okay, and lots of records. Measured miles work, and then there's a power, in my experience, there's a power in narrative to explain to a dispute resolver what actually happened. And that is not simply to make the complaints about the causes, but rather to explain to the extent you can what effect those causes had on on productivity, productivity and non-productivity of the works. I can't say much more about disruption. There is no right answer to disruption, but there are some of the things which do help. And then finally, glad to hear. Final slide. So just two insights and words of caution to mention. So the first is from what we refer to as the Engineer's Bible. So this is Max Aberson's book on engineering law and the NEC contracts. If anybody's old enough to have the joy of working with the old NEC contracts before, sorry, the ICE contracts before NEC. So this was first published in 1965, but remained in further editions up to, I think, maybe 2005 was the last update of this book. And Max says it is impossible to exaggerate the extent to which lawyers can find unexpected grounds on which to cast doubt on evidence if it is not backed up by meticulously established records. So look at it's records, and that point is very relevant if you're running into a dispute, a time-related dispute. You don't have the records, and you're having to rely on witness statements. Witness statements, in my experience, won't cut much mustard compared to hard contemporaneous facts. So facts, records. And this one I want to share with you because this comes up. This is my final point. This comes up surprisingly regularly in this practice, and this debate, which I just run through, comes to us from all sorts of people, and it right up to CEOs of gigantic contracting firms. And so it's really quite surprising, but I feel duty bound to sort of to bring it to your attention. So it runs like this: the client says the critical path is clearly through delay event or delay event 1, which is an excusable event. And then I say, well, I agree regarding the critical path, but I'm not quite sure you're as strong on liability as you think. And I only say that because Adrian's told me that. I don't have my own view on liability. And then the client says, and this is the bit, this is the caution. The client then says, it doesn't matter. Delay event 2 was happening at the same time, and it's a penalty kick on liability. It was concurrent. So if we lose on delay event 1 on liability, we have delay event 2 to fall back on a different critical path. Happy days. Our case is tight, is bulletproof. Now the problem, that approach is to say that critical path can be determined or influenced by liability, but it's not. And critical path can't be switched based on liability. Critical path is simply based on the facts and applying the facts in the program context. And once you cast the critical path, it is cast. Okay, it can't be switched because you lose on liability on the events which are sitting on the critical path. Those events, once the critical path is cast, those events are non-critical and didn't affect completion. So do keep that in mind. Hopefully that makes sense. And I'm sorry I've slightly overrun. I've tried my best to rally through it. Hopefully not too quickly. So we'll go to the questions and answers, I think.
Niall, that's tremendous. Thank you for that, and Adrian as well for yours. And yes, it's mind-boggling, I think, the level of detail, but it's clearly a hugely objective area and not one to be taken lightly. I'm conscious of the time, but I'm equally conscious that most of the people who logged on have stayed with us, so they're finding this of great interest, which is fantastic. The question, with relatively few questions, so people are being very coy, as expected in these matters, but I have a question asking, and maybe one for Adrian. When do various time bar terms actually become unfair contractual terms? Is there a tipping point?
The answer to that is rarely, bordering on extremely rarely. When you start talking about, look, it's not impossible. So the time bar provisions in a contract can become unenforceable by virtue of UCTA. But and the question is when does that happen? When does that happen? It's whenever the time bar falls foul of the reasonableness. I keep doing this today. The reasonableness test, and that in itself is a bit murky in terms of lacking clarity a wee bit. So, and by that I mean each clause and each contract will be looked at based on the underlying facts, looked at in the bargaining position of the various parties, whether the parties took legal advice, and it doesn't just fall foul. A time bar won't be unreasonable just by virtue of the fact that we think that it's unfair. It has to be legally unfair, or legally unreasonable, sorry, which is a very different concept. And in our world, a lot of contracts are negotiated, tendered. Nobody's being forced to do anything. They've signed up to stuff that they all, they know what they're doing. Most of your members are very, well experienced, work on complex matters and legal issues. So in our world, it'll be quite rare to find a time bar that falls foul of reasonableness. The one circumstance we might find the unreasonableness test being passed is where the time bar is basically rendered practically pretty much impossible to adhere to. So there's a case from not that long ago, I'm just dredging my memory, where the time bar was, you have to notify the claim within 35 days of a defect happening, or whatever the language was, or becoming apparent. The defect was in the ground, and it was therefore impossible for the party who was seeking to make the delay claim to identify the event, because it wasn't visible to them. So and that's really badly explained, but it was literally impossible for them to comply with it because the issue that they were supposed to have notified wasn't apparent, so or couldn't have been apparent. So in that case, I think the judge held that the clause was unreasonable. But look, I think that's a very rare example. Sorry, that was probably badly explained, but rarely is the answer.
Yeah. Lovely. There we go. We'll go now. Thanks. Just another one, Adrian. I know you and I have had a quick chat about this in terms of change of law and the upcoming change in terms of red diesel and so on. So where does that fit into the context here about time-rated claims and the definition of when that claim can occur and when it should be submitted and so on?
Yeah, so as you might imagine from me, because it's I'm like a badly broken record. The answer is it depends. So you got to be digging out your contract, whether it's your NEC 3 or 4 or your JCT, and looking at what the change of law mechanism is within that contract, and whether or not there might be a delay entitlement or an EOT entitlement as a result of a change in the law. If you're looking at the NEC X2 provision, if there's a change in the law, then that in the country in which the site is based, then that's going to be a compensation event, I suppose. And similarly, you'll find that in JCT, I think the language is if there's a statutory authority exercises its powers after the base date to change the law, then that's also a relevant event. So you got two triggers there, most likely, to my mind. And obviously each case turns on its facts, but the difficulty is going to be then linking delay to the relevant change in law. And that's where you start to float between my world and Niall's world. How are you going to demonstrate, for example, the red diesel issue? How are you going to demonstrate that change in law has actually caused delay rather than just increased prices? Now, in the NEC 3 world, it's a compensation event either way. But if you have a quick look at the relevant matters rather than the relevant events under JCT contracts, then it's not. So, but I'm talking about standard terms, which makes me nervous because a lot of these have been amended by scheduled amendments and Z clauses. So it depends on the contract, Mark.
That's great. And Niall, you raised your favorite topic of concurrency, which sounds like a fabulous concept, but as you say, you find it rarely occurs. You'll be aware we have, and then I agreed with the executive, the procurement advisory note, which allows contractors to submit claims for the extraneous factors in terms of global markets with material prices and so on, and delays in materials. Now that's over and above your contractual entitlements, but if you were looking at a program, how do you isolate those extraneous factors and attribute, I suppose, the responsibility for them?
Yeah, in terms of procuring materials, is that what you're?
Yes.
Yeah.
Yes.
Well, procurement of materials and anything else in a construction contract in a program context is just the same as doing work. It's just you're not doing work on the site; you're doing work off the site. So it could be very comparable to doing a design. So if the effort in that regard is included in the program, then it can be tracked alongside the physical activities and the progress of those activities going to whether they had a critical effect or not. Did they sit in the critical path? Now, a lot of programs we see will simply be construction programs. There'll be a procurement effort going on in the background, but that procurement effort won't always be described in the program. So in those circumstances, facts which would give rise to the possibility of there being a procurement delay would be elements of the site ready for the next element of construction, but not progressing for a reason. And one of those reasons is most likely resource driven, whether that be people or whether it be materials. So what the circumstances, those particular circumstances you described with respect to procurement of materials, I mean, they're not in the program context. They're no different than the normal run of the mill. The particular circumstances globally may give rise to an increased possibility that such events would find themselves in the critical path. But at the end of the day, it simply comes down to the facts as to what happened. The only exception that I suppose is if you're working, if you're claiming for the effect which hasn't yet happened. You realize that there's an issue, and you wish to claim extension of time or prolongation cost based on the issue. And that's simply a matter like anything else, as making the relevant notifications and making a demonstration based on the contemporaneous program that there's likely to be effect either on the works or on the critical path running to completion.
Great. Thanks for that, Niall. Okay, we'll have no other questions there, and just mindful of the time, but obviously huge content in that. We have recorded this. In the next day or two, we'll upload this to our YouTube channel. In the meantime, we will share with everybody who's registered your contact details, Adrian and Niall. So thank you both very much. That was extremely comprehensive, food for thought, and I'm sure a lot of folks will maybe want to have a chat with you offline and follow up on that. But again, thank you both for presenting today. Thanks to Selig for your support. Happy Christmas to everybody. This is our last Selig CEF webinar of this year. We are back in January. So as I say, go to the CEF website, get yourselves booked on the next webinars. But thank you all for your attention today. Really enjoyed it. Have a good Christmas.
Thank you.